think it's section 3(4) of the 47 Act, is extremely limited. We now have a constitution that goes far beyond that. And that is the rights that he seeks to enforce before you. Thank you, Chair.
Ms. Hassim? I'm directing myself to her because
Indeed, Chair.
she was to have argued these issues.
Chair.
Thank you.
Chair, first of all, I'm surprised that my learned friend is raising this now.
Yeah.
Because we've moved past
in
it.
fact, I wanted to say, but I just wanted to give you an opportunity. I wanted to say to Ms. van den Heever, raise your issue in relation to a specific question that has been put to Mr. Matlala, and let us see how the right you have, the constitutional right you have in mind arises. So it must be specific, and it must relate to a specific. That's how I wanted to, but...
I'm quite happy with your response, Chairperson. So I do understand that the client is entitled on each and every specific point to raise the constitutionality or the constitutional aspect that he says he lays claim to. Thank you, Chair.
Thank you.
Thank you, Chair. And that was a bit of a concern for me because I didn't know whether we're reopening the application that was brought, but I think it has since been resolved. So that is how I deal with that letter, and as I said, I will deal with the issues arising from the recordings in the manner suggested by the Chair. I have read the letter into record to state that there is nothing before us that informs the Commission that Mr. Matlala is a suspect in any ongoing investigations on matters arising from the recording. And I'll leave it there. We will come back to the recordings as in those portions as and when are necessary. Moving on then, Mr. Matlala, I would like to refer you to your supplementary statement at page 18. You recall yesterday when we engaged regarding your relationship with Mr. Hangwani Morgan Maumela and Mr. Suleiman Karim, you provided a joint response at page 18, paragraphs 93 and 94. Yes. You recall that, yes. And we had a discussion about your paragraph 93, wherein you advised that your legal team was in the process of collating, it was subsequently corrected, documents that will prove that you are a suspect in matters relating to your relationship with either both or either one of the people identified there.
Yes, I do.
And to this end, there was a discussion around a quote-unquote SIU document, which, if you heard the Chair, we resolved that it shall be made available to the document that is sought to be relied upon shall be made available to the Commission. Okay. You recall that. And I confirm it has since been made available. Commissioners, the document made available in file 11. Now, what was made available to us as this quote-unquote SIU document appears to be the special tribunal, the SIU Special Tribunal order of the 29th of September 2025 by the Honorable Madam Justice Victor. It's an ex parte application for a specific order, and it's brought by the Special Investigating Unit and lists 78 respondents. My reading of this order is that it quotes as a second respondent MHR Maumela Family Trust. It cites as a third respondent Mr. Hangwani Morgan Maumela NO, and then it cites him in his personal capacity as the eighth respondent. Do you confirm that you are not a respondent in this particular application?
Yes, I do.
And this order was basically a freezing order of certain properties registered either in Mr. Maumela's name. And if we go to typed page 4 of that, that would be paginated 6. At paragraph 2, you'll see that this is an interim order. It says pending the final determination of the 41 separate civil proceedings to be instituted by the SIU, and then it issues the order. If we go to paragraph 2.1 overleaf, it appoints a curator bonus. And 2.2, it interdicts and restrains the specified respondents from alienating, selling, leasing, donating, transferring, or otherwise disposing of the vehicles. And 2.3, it orders the transfer of possession, custody, and control of the vehicles to the curator bonus. I see if we then go to paragraph 2.5 of the same order, at page 9, once again it specifies that the second, third, fourth, and fifth respondents are restrained from alienating or selling fixed property, immovable properties. Then it deals with the powers of the curator bonus. And at paragraph 2.13 of that order, that would be at your page 15. At the bottom, it reads, the implicated respondents and all of the other 39 entities and their respective directors, members, trustees mentioned in Annexure A, herein collectively referred to as the syndicate or the Maumela syndicate, are directed to make a full and frank written disclosure. Then it lists of movable, immovable, corporeal, incorporeal assets and all funds standing to their credit. And if we stay with that document and we try and find Annexure A, that Annexure A will be a document immediately at the end of that order. At page 20, and it's a list of 39 entities. And I see at item 36, the entity referenced is Black AK Trading Suppliers. And it lists the director as yourself. You confirm that, that's correct?
Yes, I confirm.
At 37, it's a company called Core Kabeng Trading and Suppliers, and once again lists you as the director. And at item 38, Falcon Car Trading and Suppliers, and once again lists you. Now, my reading of this document is reference to you or any companies you are associated with, what the court, I don't know where they got the phrase, but termed the Maumela syndicate, and from whom the court requires them to make a full and honest disclosure regarding funds standing to their credit, in respect of which the respondents of which you are not, or any of them, have a beneficial ownership. So there's specific declarations that the entities are required to make for purposes of this litigation. Was that the understanding that you also got?
No, it's not.
Okay, can you share your understanding with us and the basis thereof, please?
I was of the view that all these entities and their directors, they are under investigation.
Sorry, please say that again.
I'm saying I was of the view that all these entities and their directors are under investigation.
Which entities? The entities listed in Annexure A?
Yes.
And on what basis do you form that view?
that why would they want us to disclose our assets and our bank accounts or whatever is in our name if we are not under investigation?
But paragraph 2.13 tells you why the court is interested in those entities. It specifically says those entities must make full and frank disclosure under oath of all assets and all funds standing to their credit, in respect of which the respondents in this matter or any of them are the registered or common law owners, have a beneficial ownership, right, title, and interest, or some other type of real rights therein, in terms identical to those set out in the draft disclosure affidavit. So the court tells you what the interest in those companies is. That cannot be interpreted to suggest that the companies themselves are under investigation by anybody, surely.
I hear you, Commissioner, but I think last time when you said you can extract information because this is not a code of law, even you can get information from newspaper articles or whatever, and I've been mentioning so many articles that have been from SIU and being investigated. So I do not know now because would it also apply to me that from that article that I got from the media or whatever, which I don't have now, which says that I'm under investigation, does it not apply to me?
Which article are you talking about, Mr. Matlala?
It's quite a lot. I can just Google now, I can...
In reference to the engagement
SIU,
we are having,
yes.
what article? Perhaps can you guide me?
I'm not in position of a cell phone now that I can just check one for you now. That anything that has to do with Tembisa Hospital, I am under investigation.
Okay, so do I understand you correctly that because an article suggested you are under investigation, therefore you are under investigation and are not able to talk about the matters the article suggests you are being investigated for? Is that your take?
Yes, but I was not relying on an article. I'm saying this also proved that indeed I am under investigation, or else they wouldn't serve this to me. But beside this document, I'm referring to quite a number of articles that I know that the thing is I've never been approached by, I won't lie to you that I've been approached by an investigator saying that I'm under, I won't lie to you.
Okay.
Yes, I was never approached, but I just know that I am under investigation, which it might be true, it might not, I don't know that.
And precisely, I guess, because it might be true, it might not, articles are known to claim a lot. You have just confirmed that you haven't been approached by any investigator. So it's not confirmed to you personally that you are under investigation.
Yes, but we are using the same articles to claim that I am under investigation, the same way as you yourself, you're saying you can use articles as evidence in this commission. So I'm using the same articles as well.
Mr. Lo, isn't this issue resolved? Mr. Matlala says he has never been approached.
Indeed.
That he's under investigation. Yes. That puts the issue to rest, I guess.
I would think so, and I'd say I refer to this document because it was introduced by you.
Of course, yes.
To avoid responding to the question relating to Mr. Maumela and Mr. Kasim. Kasim, yes. Karim Suleiman, my apologies. It's been a long week already, I apologize. I'll try that again. You introduced this document in dealing with your failure to deal with your relationship with Mr. Maumela and Mr. Suleiman Karim. And you suggested in paragraph 93 that those documents will demonstrate that you are a suspect. This document will demonstrate that you are a suspect. So we have considered it, and I'm putting to you that this document has got no bearing on you as a suspect and does not suggest that you are a suspect in anything.
Okay, Commissioner, so we're saying I'm not a suspect?
No, I'm saying this document, contrary to what you suggested, does not suggest you are a suspect.
I take it.
Okay.
So I just want to understand that does this mean that I'm not a suspect in any of the SIU?
I don't know. I don't know.
Exactly.
Yes.
So I do not want to engage in something that I do not know also.
No. What we are dealing with is a firm claim you made at 93, and I'm saying the document you put forward does not support that.
I take it,
Having
yes.
done that, I'm going to invite you to then, as the Regulation 10.6 notice required of you, to speak of your relationship with Mr. Maumela on the one hand, Mr. Karim on the other hand, or collect both, if that is how it is.
Even though I might be a suspect.
In what?
Matlala, you've accepted that you haven't been interviewed or told that you're a
Yes.
suspect in arising from these documents that you were relying on. You may well be a suspect in other matters, but right now the discussion is you answered at paragraph 93 that there are documents from which it appears or it will show that you are a suspect. You've just accepted to Ms. Sello that on this document at least, the one that you were relying on, you are not a suspect, but also you've not been approached by anyone in law enforcement, it has to be, that told you that you're a suspect in these matters. I think it is fair that you should be then now required to answer now that we have established on the document that you relied on that you are in fact not a suspect, that questions that come from or relating to the 10.6 should be answered about your relationship with Mr. Maumela and Mr. Karim.
Before you leave Annexure A, Mr. Matlala, when you were first here, the Commission asked you about companies that you own or have interest in, and you only mentioned 3. But now in item 37 and 38 of Annexure A, Medicare 2024, you mentioned CAT VIP, the security company, and then you mentioned Black AK Trading Supplies. You did not, in your engagement with me, mentioned Core Kabeng and Falcon Car Trading. Why is that? Do you have interest in these companies, and why did you not mention them when I first asked you to clarify this issue?
Because those companies are deregistered.
They are deregistered?
Yes.
When were they deregistered?
Long time ago, I don't remember when, long time ago.
Because this judgment or this order of the tribunal is dated 25 September 2025, and it suggests to me that they still existed in September 2025.
Yeah, but with a quick search, we can verify that those companies are being registered, Commissioner.
All right, thank you.
May I, Mr. Matlala, with regard to the point that your entities are listed in Annexure A, you are therefore being investigated. May I ask to take you to page 16? The same, the paragraph 2.13 of the tribunal's order. The tribunal's order.
Yes.
You still have it close by.
From 2.13, right?
Yeah.
Yes.
Perhaps instead of going
It's page
straight-
15.
Yeah, let's start at page 15.
Yes.
Yes. The implicated respondents and all of the other 39 entities and their respective directors, members, trustees mentioned in Annexure A are directed to make a full and frank written disclosure under oath of all the property and or assets and of all funds standing to their credit. Now, here's what I want to engage you on. In respect of which the implicated respondents, so even though Annexure A may go beyond entities owned only by the respondents, and it includes, for example, your entities. But the part that I'm emphasizing says, in respect of which the implicated respondents, of which you are not one, or any of them, still the respondents, are the registered or common law owners, have beneficial ownership, right, title, and interest, or some other type of real right therein. So the contemplated ownership, beneficial ownership, right, title, or interest may be in your entities, for example. That is how I read this. And it does not translate to you being investigated. So it's still about the respondents. The focus is only on what interest they may have in other people's entities. Do you see what I mean? This is just to reinforce the point made by Commissioner Baloyi, which is that nothing here suggests that you yourself are being investigated. Would you agree with that?
I agree.
Thank you.
Thank you, Chair. Then, having disposed of that, let's turn back to our paragraph 93 of your supplementary statement, and we do so with reference to the Regulation 10.6 notice issued. The Regulation 10.6 is the first document in your main statement file. And you recall that, as we did with General Sibia, you were required to explain your history and your relationship, direct or indirect, with certain persons, and they included Mr. Maumela and Mr. Karim. So can we then, in the context of 2.2, deal with your relationship with Mr. Maumela?
Chairperson, sorry to interrupt. I'm wondering if yourself and my learned friend has taken into account the provisions of Section 332 of the Criminal Procedure Act, which deals with one being an accused person or a suspect by virtue of your company or the entity of which you are a director, and in relation to your directorship in respect thereof too. So that, by virtue of that fact, you are also, and you can also, and he's also vis-a-vis this particular order, based on what he said, a suspect in that particular matter.
No, I don't agree with that, Ms. van den Heever. I do not agree with that. This concerns property interests, beneficial interests of the respondents. And the point is that those respondents may have interests in entities owned by other people. So the order relates only to their interests in those other entities, entities that are not theirs. That's all it is about. I've not read what this is about, but I'll just assume perhaps that it was about the seizures that usually emanate from that entity. The tribunal. So it makes sense that the tribunal would be interested in, fine, we got hold of these Lamborghinis and this and that, but what other properties do you own? Do you own any beneficial interest in other people's companies? The focus of the tribunal will only be on what the respondents own. And that they may own that in someone else's entity does not make that entity a respondent or subject to investigation. There's a leap in logic in suggesting just because I want to know whether Ms. van den Heever has a beneficial interest in Commissioner Baloyi's company, then Commissioner Baloyi's company becomes involved in whatever it is they require information from you about. I do not understand that logic.
Chairperson, maybe I've had the benefit of reading through the actual application and the affidavits that was, because I went to the trouble after we were here to get those. Maybe if I can suggest, I see it's almost 10 o'clock.
But in any event,
I can,
yes.
Because it refers specifically in the order to the set affidavit that relates to the issues of the Maumela syndicate that is discussed there. As I said, I don't want to place facts before you without just going to refresh my memory again on that. That's why I'm asking, maybe it would be convenient.
In any event, what should cut across all this, Ms. van den Heever, is to avoid us debating issues in general. if there is a specific crime with regard to this, in respect of which Mr. Matlala is asserting the privilege, let that be specific, please, in the interest of time.
And that's
Otherwise,
exactly-
the day will go by without us covering any meaningful ground.
And that's exactly what I'm going to endeavor to do for you during the tea adjournment, to make sure that that is brought to the attention. The client, as chairperson knows, is a layperson. He doesn't know the niceties of the law when it comes to these issues. So please afford me the opportunity to pull those up and have a discussion with the client.
But whatever you pull up, bear in mind, because a lot may be said, affidavits in proceedings may go far and wide. Bear in mind that what I have referred to in this order, the tribunal's order, shows in so many ways that this is not about Mr. Matlala's entity. It's about someone else owning something in Mr. Matlala's entity. Bear that in mind. So whatever